Okay, here comes another one. And I just want to thank Alejandro Velasquez for compiling these questions from a bunch of musicians in the Madison area with his network. Here's a copyright question.
Okay.
At what point does your band own the music they make? Once they write it? Once it's on a CD? Once it's recorded? When does a band own the music they make?
Well, there's what's called common law copyright, which means that once you create it and fix it onto a CD or your phone for whatever, once you fix it onto a place that it can be played back, for example, or even sheet music, then you have what's called a common law copyright, meaning there is general protection if you can prove that you wrote it at that particular date. But the best thing to do is to file for copyright with the Copyright Office. It's not very expensive. It's $35. You can do it online. And the key here is that it's very difficult to enforce your copyright unless you have this federal copyright document. The copyright, the registration, gives you the right to threaten for statutory damages, which could be up to $150,000 for each violation of the copyright. So if somebody steals your work, having a registered copyright is twofold. First of all, it's a clear document that you own the work, and there's a recording. The Library of Congress keeps a copy of that recording, so that there's evidence there that you created that song on that particular date and it's registered. That's number one. Number two, you can also threaten to go after statutory damages, which is $150,000, and that's much more. That's a much more aggressive penalty than the state common law rights, which are much more difficult to enforce. And really, with the state common law, you're stuck showing that there were damages to you and that there's income there that you've lost or that maybe this other person's gained as a result of stealing your work. And sometimes that income might not be very much money, but at least with federal, you get to threaten the statutory penalty. Now, in copyright lawsuits, it's not often where they award the full $150,000, but just the threat of it will make various entities offer a settlement of some sort, and you can probably resolve this without going all the way through a lawsuit.
Cool.
This is especially true for record labels. If somebody has sampled your work, maybe it's Kanye sampled your work or somebody without authority, then and you have a federal copyright, you're in much better position against a bigger label. They will take you seriously and try and resolve probably make an offer if there is a substantial use of your work and you can prove that you had the registration.
Okay, so it sounds like a good. Yeah, that's great. Sounds like a good $35 to spend, and I know that you can put more than one song on a copyright form. You can put an entire album on one copyright form. Is that correct?
Yes, you can. But you remember that the songwriters have to be the same. It has to be the same configuration of people. It doesn't have to be the same splits because the copyright form doesn't require that you list what the splits are or the percentages, but it does have to be the same writers. So if two guys wrote a whole album together, you could copyright the whole album and list those two guys as writers and list the title of the album, and then the alternative titles would be the songs. But if two guys wrote one song and a third guy contributed on another song and a fourth guy on another song, then you're still going to have to do copyrights according to each grouping of writers.
Okay. Well, I didn't know that. That's great. And then the other thing I know is there is a 4-year statute of limitations on a copyright infringement claim.
Yeah, I believe it's even 3 years. And sometimes you could prove that you were not aware, you had no knowledge or had no way of knowing that the copyright existed, but that's very difficult to prove because especially nowadays when everything's on the internet and all over the place, you're going to have trouble. So if you feel someone has infringed on your work, you really need to see an attorney pretty quickly so that they can get the ball rolling because, yes, a lawsuit would have to be filed within a 3-year period in order for you to claim copyright infringement. Now, if the infringement is ongoing and they're continuing sales, you could claim it later on down the road, but you're only entitled to revenue from the last 3 years unless there's other. It gets a little bit more technical, but unless there's other reasons why you might not have had knowledge or you might not have been aware. So, best to get it done as soon as possible.